All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to your North Carolina Court of Appeals. My name is Judge Chris Dillon. I'll be presiding today. To my right is Judge Hunter Murphy, and to my left is Judge Toby Hampson. We have one case on the calendar. It's Sanders versus NC Department of Transportation. And if the appellee is ready, have y'all figured out how y'all want to divide up the time and do all that, I guess?
Yes, Your Honor. The clerk went over that with us earlier.
Okay. Awesome. So we'll hear from the appellant first, and just let me know if you want to reserve some time.
Good afternoon. May it please the court. My name is Jeremy Hopkins, and I'm here with George and Stephanie Autry, and we represent the plaintiff, William Sanders. And at this time, Your Honor, I would like to reserve 5 minutes for rebuttal, please.
Okay.
There is one undisputed fact that is determinative of all the issues in this case. One, and it's a stipulated fact. And that fact is this. This case involves 4 different takings of 4 different property interests that occurred at 4 different times. It's undisputed. The first taking occurred in 1992 when the DOT placed a negative easement on the property under the MAP Act and encumbered 92 acres. The second taking occurred in 2002 when the DOT took property in fee interest and affirmative easement interest on a separate portion of the property for a separate project. That was in 2002. The third taking occurred in 2006. And that was when the DOT put another negative easement on the property and encumbered an additional 20 acres under the MAP Act.
Was that for the same project as the 1992?
Yes, Your Honor. Both of those were.
So the 2002 had nothing to do with
That is correct.
Okay.
And the fourth taking occurred in 2010. And the fourth taking was, again, a fee interest taking with affirmative easements. And in the taking in 2010, the DOT took in fee all but 28 acres that had been encumbered under the MAP Act.
So there were 112 acres that were encumbered, and they took all but 28 acres.
Yes, Your Honor. They took all but 28 in fee in 2010.
Okay.
And that's important.
And was the 92 acres? Was the 92 acre tract separate from the 20 acre tract? Are we talking about 2 tracts?
We're talking, for purposes of eminent domain, it was one large parcel, and the 92 acres was separate from the 20 acres.
I got you.
So two negative easements on the property, separate portions of the same property.
I got you.
And what's important about that fact, 4 different takings of 4 different property interests at 4 different times, is that the taking of one property interest cannot be, and has never been held to be, a waiver of the owner's constitutional right to compensation for the other interest. Simply stated, for a condemning authority to take one interest in a piece of property in no way deprives an owner of just compensation for the taking of a separate interest, especially when those interests were taken at different times. All of the cases recognize that. All of the cases the DOT raises for its statutory argument for its construction of 136-111, whether it be Lee Company, Spratt, Bragg, Cromartie, Farrell, every one of them recognize that the owner had a right to bring an inverse condemnation action, either through a counterclaim or an independent action, to recover compensation for the taking of a separate or different interest.
Well, what are we to make of the prior panel's use of the word prior consistently in these? In Lee and in Bragg, at least, that they're not banned from
Yes, Your Honor.
further taking by the state after initiation is what I'm pulling from Lee. You know, it's this after effect.
Yep.
And none of them seem to really be addressing this previous effect. Is this, you know, recognition in Lee and Bragg just our general application of the rules of civil procedure, and when it comes to compulsory counterclaims, that obviously something arises later, you don't have to go back and bring it as a counterclaim in this already going on action?
Not at all, Your Honor, and this court has actually already decided that, and I'll address that directly. In those cases, the reason they speak in terms of prior is because in those takings, and when I refer to those, I'm referring to Bragg, and I'm also referring to Lee Company. The inverse condemnation arose after the DOT had filed its complaint in those cases. There are two cases that are critical to answer your question, the first being Spratt. In the Spratt case, that was one where the inverse condemnation easement arose before the city filed its complaint. And if you take a look at Spratt, and it's cited in our brief, the court was very clear to say there that even though the inverse condemnation arose before the city filed its direct condemnation complaint, the owner was still free to bring an independent inverse condemnation action. What's important about that is that Spratt has always been the elephant in the room. It's the North Carolina Supreme Court. The DOT did not address it until its reply brief. At the very end of its reply brief, it said Spratt didn't apply because it said Spratt was determined before the inverse condemnation statute was adopted into Chapter 40, which at the time, Chapter 40 was the provision for localities taken by eminent domain. Here's what the DOT didn't tell you, and it's immensely important. Winston-Salem versus Farrell. The DOT cites that case in its briefs, but for some reason it didn't bring this to your attention. City of Winston-Salem versus Farrell, 338 Southeast 2nd, 794, was decided by this court in 1986 after the statute, the inverse statute, went into Chapter 48. In that case, the city had taken a construction easement prior to filing its direct condemnation complaint to build its road. After the city filed its direct condemnation complaint, the owner sought to bring an inverse condemnation action for the prior taking of the easement, the construction easement. Citing Spratt and relying upon the statute expressly, this very court said the owner was free in City of Winston-Salem versus Farrell to bring an independent inverse condemnation action or to bring the inverse condemnation action as a counterclaim. It decided the very question you asked, Your Honor. Unfortunately, the DOT didn't bring that to the court's attention. It simply cited Spratt and said it wasn't applicable because the statute wasn't in existence, never brought the Farrell case, that portion of the Farrell case, to this court's attention, and it directly answers that question. If the DOT were correct, the DOT could simply use somebody's property for 5 years, and if the owner doesn't bring an inverse condemnation suit within that period of time, the DOT could rush to the courthouse and file a complaint, and according to the DOT, the owner couldn't bring an inverse condemnation action for the 5 years that the DOT previously used its property, and the owner also wouldn't have standing because now the DOT would own that property. It just makes no sense. Again, if the DOT were to use my property for 5 years and then rush to the courthouse in year 6 and file a direct condemnation complaint, in no way does that relieve the DOT of its duty to pay me for the previous 5 years that it used my property. And in fact, the United States Supreme Court has addressed that issue. In First English, which we cite extensively in our briefing, in First English, the Supreme Court said, and I quote, "Where the government's activities have already worked a taking, no subsequent action by the government can relieve it of the duty to provide compensation for the period during which the taking was effective." And what's critical is when you go look at that provision in First English, the court said it doesn't matter whether the condemning authority tries to repeal the statute or the offending ordinance. It doesn't matter whether the condemning authority subsequently files a condemnation. Once it's been established that there's been a taking, and don't forget here, it was stipulated that the MAP Act takings here occurred in 92 and 2006. That's a stipulated fact. Once the taking has occurred, there's nothing a condemning authority can do to relieve itself of the duty to compensate for the time in which that prior taking occurred and the time in which the owner's prior taking was used. Now, this is immensely
But it seems
important.
to me, as a broad proposition, the trial court generally agreed
Yes, sir.
with that point,
Yes, sir.
right? And it's not saying you do not have a claim for inverse condemnation for the negative easements. We're really talking about the delta, right? The difference between what was allegedly or arguably resolved by the fee simple acquisitions
Absolutely, Your Honor.
and the broader negative easement. So, so what can you point to say that delta should also be covered and not deemed
Your Honor,
resolved?
you are absolutely correct. We agree, we being Mr. Sanders and his counsel, we agree with 90% of what the trial court did. The one sole mistake the trial court made, and the trial court got confused, and there was a lot thrown at the trial court. I don't fault the trial court at all, but what happened was the trial court concluded that nothing in the consent judgment transferred a negative easement. The trial court's finding of facts are correct. Nothing in the consent judgment in 2010 from their direct condemnation action mentioned the MAP Act, mentioned the restrictions, didn't refer to it all. And the trial court concluded that that consent judgment did not convey the negative easements, and Mr. Sanders did not waive his rights under that consent judgment. The sole mistake the trial court made was the trial court then said, because in 2010, and the trial court also noted that the consent judgment made reference to no time period except for the data taken in 2010. It made no mention of the 18 previous years, 92 to 2010, that Mr. Sanders' property was restricted under the MAP Act and under the negative easement. Where the trial court went wrong is the trial court said when the DOT acquired the entire bundle of sticks in 2010, and we don't deny that, as of 2010, August of 2010, when it filed its complaint, the DOT did acquire the full bundle of sticks. But in no way is that retroactive. And no court that I know of in anywhere in this country has ever applied a direct condemnation retroactively, especially when the prior taking was not mentioned anywhere in the consent judgment or the complaint. And as a matter of fact, the case that the DOT cites, Town of Midland versus Wayne, it says as a matter of basic due process, in order to take a right from an owner, in order to deprive an owner of that right to compensation, at the very least, the property right has to be identified and described. That's a basic notion of due process. So the only mistake the court made was applying that 2010 taking. When the DOT got the bundle of rights in 2010, they got the bundle of rights going forward. They certainly didn't get the bundle of rights going backwards. That, we wouldn't be here today.
Going
but-
forward and backwards from when? Because I'm looking at paragraph 5 on record page 86. It does seem to encompass some past acts at a minimum. Is it not? Or any all damages caused by the acquisition for the construction?
Are you reading the consent judgment, Your Honor?
Yes, sir.
I can answer that. No, Your Honor, it does not cover that. What the consent judgment, it says past and future use of the property. That doesn't, and the trial court was correct that that language did not cover the MAP Act for two reasons. First and foremost, a negative easement is not a use of the property. No one's ever contended a negative easement is a use of the property. And we cite in our brief the DOT's own manual that says the negative easements do not give the department any right to enter, occupy, possess, or use the property. The DOT had to file the 2010 direct condemnation action precisely because it had no right to use the property and no right to construct anything on that property. So there was no use of the property under the MAP Act or the negative easements. That belies the very definition of a negative easement. And when it refers to past and future, that's standard language in every consent judgment. What that's referring to, Your Honor, is when the DOT files a direct condemnation action, they file a complaint. Sometime after the complaint is filed, in many of these cases, there'll be a settlement and a consent judgment gets entered. The reason they would speak to past and future damages, the time between the time the DOT files the complaint and title transfers from that point forward to the time the consent judgment is entered, that's the past use of the property. It's the little time period between the time the complaint's filed and the time the consent judgment is entered, and the DOT's used it. That's the past use. The future use is from any point from the consent judgment forward. But again, past and future doesn't even matter because under the MAP Act, there was absolutely zero use that the DOT could make of the property. The DOT goes so far as to say that their language, their standard language in a consent judgment, which says that the owner waives all right to damages from the acquisition of the construction of the project, somehow encompass the MAP Act. That's outrageous. The MAP Act gave them no right to construct anything. The acquisition for the construction of the project was the 2010 direct condemnation action the DOT filed. They had to file it because they had no right to do any construction.
But I'm looking at, it's very specific. It's this project ID number. And when I look at the maps that I think is being referred to with that, it's like around Doc Exhibit 3 and 4, in what was submitted, those plans go back to 2001. So is that not inclusive of what was filed as part of the MAP Act?
No.
Or is it just related to this single project that resulted in this single taking and condemnation action in 2010, even though they look like their maps are 9 years before that?
What's important to note, if you're looking at the project number, actually another further proof that the consent judgment did not refer to the MAP Act. The MAP Act encumbered the property under two segments of the project, segment CA and segment CB. If you take a careful look at the consent judgment, it only speaks in terms of one segment, CB. That's just further proof. Mr. Sanders' property was a huge property. It was 700 acres. I mean, it was enormous property. It covered a huge segment of this project. And the DOT's consent judgment in 2010 only covered a portion of that, just the CB is all it spoke to. But again, that consent judgment couldn't possibly, when you're talking about, does Mr. Sanders waive rights to be paid under the MAP Act for a negative easement? Under the language, it's saying he was paid for any future or present use of the property. The MAP Act gave no right of use. There's no way that that phrase can be deemed to be a negative easement. A negative easement is a restriction on Mr. Sanders' use. In no way did it give the DOT a right of use, and in no way did it give the DOT the right to construct anything. That's standard language that's in every consent judgment. And you know what's funny is that, and we cite this in our brief, the DOT, when it wanted to pay somebody and asked them to waive their MAP Act rights as payment, guess what it did? It didn't just use the standard language that they used in Mr. Sanders. They went in and they put in separate sentences that specifically said, consistent with due process, that the owner is waiving their rights under the negative restrictions, under the negative easement or under the MAP Act restrictions. And we cite examples of that in our brief. But to say that the use of the property somehow encompasses a negative easement belies the very definition of a negative easement. Negative easement gives no right of use, no right to construct anything. That's the very reason that we were there in 2010 for the direct condemnation, is the DOT had to acquire the right to use the
I
property.
have two questions, one pertaining to that. The first question is, I assume Mr. Sanders owned the property in 1992.
Yes, sir.
So he's at all times been the owner.
Yes, sir.
So when the taking, whoever owned it in 1992 is entitled to bring that action, because that's when the taking occurred. That's when that taking occurred in 1992 when the map was filed. Is that correct?
Yes, sir, that's correct.
Okay, now I want to go back to paragraph 5 on page 86 of the record. It says you get compensated for whatever the value of the it's just compensation for whatever the interests were named in the complaint, which you're saying that the negative easement wasn't anything. Now, but I do have a question. Then it says for all damages caused by the acquisition for the construction of Department of Transportation project. When they acquired, wouldn't you say that could it be argued that the Department of Transportation acquired a negative easement? It is a right. They didn't have this isn't the use language, it's the prior one, that you were being compensated for all damages caused by the acquisition for the construction of Department of Transportation ID, blah, blah, blah. And so what was acquired? They had the fee simple acquired in 2010, but they also acquired a negative easement in 1992.
The negative easement was not acquired for the construction. Two things, Your Honor. Number one, that speaks
Well,
to...
but I hope it is, because then your statute of limitations is run. Because you have 2 years from the time, it's got to be tied to that project, or you don't have the claim at all.
No, sir, the project, even under the facts, the stipulated facts, didn't end until 2020.
So, so it is the project. We're talking about the same project.
Oh, it's for the same project, yes, sir, but it's not for the construction. And things are taken all the time. I mean, if you look at this court's decision in Baroth, the 2017 opinion, page 494 and 495, this court said very clearly that the MAP Act was a cost-controlling mechanism. It doesn't require the DOT to
But
build
the
the road.
Supreme Court said it's not. It's an act. The DOT acquired a negative easement. They acquired. Did the DOT acquire negative easement rights over Mr. Sanders' land in 1992 when they filed the?
They acquired a negative easement, yes, sir.
Okay, so here it says, was he damaged by that acquisition?
Yes, sir.
Then why is it covered? It says any and all damage caused by the acquisition for the construction, any acquisition that Mr. Sanders suffered, damages caused by the acquisition for the construction of this DOT project number. So you just admitted that he was damaged, that the DOT acquired land for this project in 1992, that he was damaged by it, and this consent agreement says that he's being compensated for all damage caused by the acquisition for the construction of, and it's,
There's a difference between being acquired for the project and being acquired for what the consent judgment says, and that's the acquisition for the construction. On page 525 of the Chappell decision, the Supreme Court of North Carolina says very clearly, the MAP Act does not result in the building or widening of any road. There's a big difference between the project and the acquisition for the construction. They had no right to construct anything until 2010. The acquisition for the construction, again in the singular, which is the standard language they use in their direct condemnation consent judgments, occurred in 2010. The 1992 negative easement, you are correct, was for the same project. We don't deny that. It was for the same project, but it was not for the construction of the project. As this court said in Baroth, it was a cost-controlling mechanism. It was to keep costs down, not so that they could construct anything.
But if it's not related to, and this might be getting a little bit too deep on the inception and trying to figure out where this all fits together as an overall puzzle, if it's not related to the construction of a transportation project, then how is it a lawful taking to begin with? Because then it's not for public use.
It was,
And so if there's not a public use attached to it, which would be the eventual construction of a road project or whatever the state may take it for, then it's just an unconstitutional act because it's not actually a taking for public use.
well, it's for public use because it's for the project. But again, I go back to just because
The
it's for,
project is the construction of a road, right? Not just the state's going to hold on to a bunch of land.
sure, the project ultimately resulted in the construction of a road, but that was not, as the consent judgment says, the acquisition for the construction. If they had never filed their 2010 direct condemnation action, they could have never constructed anything on Mr. Sanders' property. And as a matter of fact, 28 acres that were still encumbered, the 28 acres that were still restricted, were never used for any road. But that doesn't mean they didn't encumber that with a negative easement for that project, but they were never used for any construction. So when the DOT, who drafted the consent judgment, said the acquisition in the singular for the construction, it's clearly speaking in terms of the 2010 acquisition, because the 92 acquisition and the 2006 acquisition gave the DOT no right to construct anything, and the 28 acres were never used for anything.
So I was an eminent domain lawyer, so explain to me, okay, this clause, this paragraph 5 sets forth you get just compensation for the interests that are described in the complaint.
Yes, sir.
What could all damages caused by the acquisition mean beside just paying just compensation for the interest acquired? What other damages are you entitled to as a landowner besides?
That's easy, Your Honor. It's all the damage to the remainder. So, for example, if I have just to keep it simple, if I have a 2-acre parcel and the DOT takes an acre through the middle of it, I'm not only entitled to being paid for the acre they take through the middle, but when they construct that highway, if they split my land in two, and now I have damages, I have 2 severed parcels, those are damages from the construction that flow directly from the construction. The Bragg case is another.
If you have one 2-acre parcel and they take half of it, or they put a road in the middle of it, well, isn't that just part of your just compensation and the value before, value after? That is your just compensation. I'm trying to figure out what this clause can mean, and for all damages caused by the acquisition, it's got to mean something different than just the just compensation that you received for the taking that's described in the complaint.
The just compensation is called damages, and so when they refer to it, that's how in an eminent domain case you refer to the just compensation. A lot of the jury instructions.
But paragraph 5 has 2 clauses. It says you get paid just compensation, and then you also get this thing called all damages caused by the acquisition, which could be argued to mean the negative easement from a long time ago. You're saying it doesn't mean that. So I'm just asking, what could it mean? It can't mean just compensation, because otherwise this would be superfluous, if I can say that word.
I'll give you a great example.
Give me an example of where I could, as a landowner, get damages on top of the just compensation that I'm constitutionally.
The Bragg case. In the Bragg case, there was a condemnation. There were additional damages that were inflicted as a result of that, and Bragg sought to put those damages before the court. In the condemnation case, those were additional damages.
What were those
that sought.
damages?
There was some flooding and things of that happened from the
So
construction.
that was a flooding easement.
No, sir, they didn't take it. What happened was from the construction. It was actually from the acquisition for the construction. They were flooding the property.
So it wasn't called an easement or an interest in land. It was just they just damaged the property.
Yes, sir. And that's in Bragg.
So that wasn't an inverse condom. But I thought they
No,
described it as
Bragg brought it just directly, and the court said he could bring it as an inverse, but what Bragg did,
well, then it's a taking. And it's a
Well,
taking of an interest. It's
not
a taking of interest, and widening the negative easement, the same thing.
what the court said in Bragg is the owner didn't have to bring the inverse. The owner could also just bring it, and the condemnation was still pending in Bragg. And so in Bragg, the court said the owner could still put those damages before the court. The court said he could, in a footnote, the court said he could, if he wanted to bring an inverse, he could, but he didn't have to because the condemnation was still pending. They said he could bring those additional damages before the jury in that proceeding, since it was still ongoing.
But didn't Bragg describe it as a taking? It's a type of taking. You can bring it as an inverse condemnation, or you're taking it. That's my whole point is, then it covers, you described the damage that would be covered from some other taking that's not described in the complaint, which would be the negative easement as well. I'm trying to think if they could just, is there some kind of damage that's not a taking that I would be entitled to some kind of damages?
No, anytime there's a damage, it's going to be a taking. You're going to be entitled to compensation. But I think what's critical and what's being missed is the date.
Well, if
But
a
talking about the
DOT
date.
truck comes and drives over and knocks over my mailbox, there's no taking, but well, I don't know if I could sue the state. There might be sovereign immunity, but that would be damage that's totally unrelated to any kind of taking. So I'm just trying to figure, is there any kind of damage that, I'm trying to give this phrase meaning that wouldn't encompass other interest in real estate, such as a negative easement or flooding easement or whatever?
I mean, from that date, the critical part is that was in 2010. So they described the date it was taken in 2010, and they're saying from that point, any damages from the acquisition for the construction. So the acquisition here was in 2010. It was the direct condemnation. That was the acquisition for the construction. So that would be all-encompassing of any damage from the construction of the project. Again, you could argue that there might be some flooding, some additional flooding. One could argue because of that clause, that flooding, if it was from the acquisition for the construction, wouldn't be covered, even though it wasn't part of the original complaint. The original complaint could say, we're taking 1 acre, just like Bragg. Could say, we're taking this piece of property. The fact that it may also give rise to an inverse condemnation doesn't mean it's not damage from the acquisition for the construction.
Did the acquisition extinguish the negative easement?
The acquisition extinguished the negative easement with regard to the land taken in fee, but only from that point forward. It can't go backwards. So when the DOT filed their direct condemnation action in 2010, whatever land was taken in fee.
Why does that matter if?
Because for 18 years, Mr. Sanders had his property.
And why does the 18 years matter if the measure of damage is diminution in value at the time of the taking?
Because just like the way that the DOT values all these indefinite easements, including their construction easements, it matters because you look at all of that. You look at the facts. You don't ignore what exists. It matters because that was the duration of the taking. And just like with their indefinite construction easements that they take every day, they value those based on the duration. And just like this court said,
Are you? I guess maybe the more direct question is: Are y'all in fact intending to advocate at the compensation trial that the proper measure of compensation is the lost rental value or fair rental value or whatever for a temporary easement versus diminution in value for a permanent easement?
we still contend it would be the before and after method, but you look at the duration of the taking, just like we do every day in all these cases across the state with the indefinite construction easements. And in Wilkie, this court in Wilkie versus Boiling Springs, 263 North Carolina App 413, it cited First English with approval. And the DOT said in its brief that First English isn't applicable because it doesn't apply to an eminent domain case. Well, this court cited First English in the Wilkie decision with approval and said the owner must be paid for the duration at which his property was taken.
I have one more question, and I will give you more time, and I'll give you more time too, because we're cutting into your time. When y'all settled the case, these were consent judgments, so y'all settled the case, and I guess got a judge to enter a consent judgment. Is that correct?
Yes, sir.
Was the understanding between the parties that I guess it was based on some kind of before and after value, y'all went back and forth. Was it the understanding that the before value took into account that the before value isn't that high because it was subject to this negative easement and y'all thought you were going to get paid for that later? Or were y'all bringing in evidence, this property could be used for a hotel and all this other stuff? I mean, because if that was your understanding, were you already compensated when you made this deal? What was the understanding between the parties?
Not at all. The negative easement wasn't at issue at all in this case. And importantly, not only in the before value, but also the after value. No one considered that it had been restricted for the 18 years. Nobody considered it would continue to be restricted for an indefinite period of time afterwards as well.
Well, when you considered the before value in 2010, did you consider the fact that it was restricted by the 1992 map?
Not at all. And under the
And you were compensated. You've been compensated then because if you were if you're going to be compensated for the negative easement, that's going to drop the value of the land from 1992 to 2010. And then when they take the fee simple in 2010, your before value is really low because you've already been compensated for all that. So I would hope it was considered. I mean,
under the project influence rule, that would allow the MAP Act to be used for the very purpose the court said it couldn't be used. Under the project influence rule, a condemning authority can't go and try to get the property downzoned or can't go put a restriction on it and then pay a lesser value. So that would have been totally improper.
I know they can't do that, but you're saying there was a taking in 1992 and you should be compensated. Let's say the property was worth $1 million and the taking in 1992 caused that property to be only worth $1,000 because you can't do anything with it. Then when they take the fee simple in 2010, you shouldn't get the $1 million. You should just get the $1,000, and you need to go sue for the other because the property was only worth $1,000 in 2010 because they took all that. But you're saying that when you settled it, y'all were all thinking it was worth $1 million, not the $1,000, which tells me that you didn't consider the fact that the property had this negative easement. You already been paid for it then.
Not at all. Mr. Sanders was never paid for the period of time. No appraiser ever considered the map restrictions from 92 to
Well, they
10.
should have. Should
or-
they have considered
or-
it in setting the before value? To set a before value, you got to say, okay, what's this property worth in 2010? This is a piece of property that is subject to a big negative easement, because this is a new taking. 2010 is a separate taking from 1992. You're entitled to that 1992 damages, but it seems like y'all thought about that, or basically, when you agreed, you were agreeing to take fee simple based on the value that it wasn't encumbered by this negative easement.
I disagree, Your Honor. The reason I disagree is, one, project influence. They couldn't devalue the property and take it at something less than its market value. But two, it goes back to separate interest. If I rented my home for 20 years, I would collect the lease. And if in 21 I wanted to sell that home, I get the full unencumbered value. They don't, and so I'm not getting paid twice. I'm getting paid for separate interest.
Oh, I know, but if I have a piece of land that I can build a hotel on, and then they do a map act, and now I can't do anything, now the property's only worth $1,000. In 2010, when they actually take fee simple of my property, you shouldn't be able to come in and say, hey, I can build a hotel on this property, it's worth $1 million. The before value should be, all I can do is this $1,000, and that's all you're entitled to. You got to do the inverse combination to get the big taking that took place in 1992 that took away, because that's where the negative easement took all the value. It's two different takings. So it took most of your value in 1992. Why aren't you get double counting if you can get that million?
It goes back to the lease example. Number one, and I go back to project influence and lease example. If you're allowed to lease my property for 20 years, and then in year 21, you don't have to pay the market value when you want to buy it in fee, I haven't been justly compensated. That's the way the market works. So I should be paid for the time my property was used, and then when I go to sell it.
This is a negative easement that was indefinite. It was basically almost a permanent easement. I mean,
No, under First English, the First English court says very clearly,
in that case.
under First English, when the negative easement, when the ordinance is repealed, it converts the taking into a temporary one, and that makes sense. That's the only way it could make sense, because when the DOT took that land in fee, they extinguished the negative easement. So the negative easement terminated on that date. Mr. Sanders, when they took his property in 2010, that negative easement terminated. He still hasn't been paid for the time previous,
my
which is
problem
land.
with that is the value, the way you assess damages for the negative easement is not what is the rental value you would receive. It's just simply a before and after. How much has the property been diminished in value from before 1992, before this negative easement was taken, when I could build a hotel, till afterwards? Now I can't ever build a hotel on this thing again. There's no lease thing. It's just the diminution of value. So now it's only worth $1,000. So we carry it over to 2010. It's still just worth $1,000 because I can't do anything on it.
Regardless how you value it, at the end of the day, he still has to be, under our Constitution, paid for each interest that was taken. If they rented his property for 20 years and then took it in fee in year 21, he has to be paid for the time they rented it, and then he has to be paid the fair market value when they purchase it, free and clear of the prior use. And that's what we're talking about today. We could certainly get into valuation. Valuation's not at issue yet. We don't disagree with the before and after method. But what we do disagree with today is that an owner must be paid for every interest that's taken from him or her. And here we have different takings of different interests that occurred at different times. Mr. Sanders still hasn't been paid for the restrictions that hung over
You
his
still have
property.
5 minutes.
And
Thank you.
Go ahead.
let me ask, just so I'm perfectly clear, the concern that you have is that that the negative easement of the land encompassed under this CB map has not been compensated from 92 to 2010.
Correct.
Okay, thank you.
Thank you.
We'll hear from the applicant. You have about an hour and a half. Yeah.
May it please the court, Howard Rhodes of the Banks Law Firm for the Department of Transportation. When DOT files a condemnation action on a tract of land, the landowner must raise any and all claims for damages on that tract existing at the time. This is the clear requirement of the state's eminent domain statutes and our law of res judicata. All damages on the landowner's property existing as of the 2011 consent judgment are waived, paid for, and released in this case. They are waived under statute, they are paid for in the 2010 condemnation proceeding, and they are released by the 2011 consent judgment.
Let me ask this real quick. Say that you filed this amount as detailed in paragraph 4 on R86, the $9 million that was paid in to the clerk, and they just exercised their statutory right to go and claim that. Would you still have this res judicata effect or the impact that is alleged to have come from this consent judgment on that prior taking, as they're alleging? Or would they have, if they'd accepted the $9 million, just taken it without going through the litigation process, would they have been barred from bringing this later, as they did?
Yes, Your Honor.
What if I owned the property in 1992 and I sold it to Mr. Sanders in 1995, and then y'all took the fee simple? That 1992 claim is mine. Can I bring it?
No, Your Honor.
So I don't own it. So if you took some of the land for the highway project in 1992, and I just hadn't sued you yet, I have till, even though I don't no longer own it, don't I have until 2 years after the project is completed to sue you?
No, Your Honor. So under Cavanis, a 1916 North Carolina Supreme Court case, and yes, we're going all the way back to some of those railroad cases we read in law school.
Because I was looking at a all I found was a Court of Appeals case called Berta that says inverse condemnation.
That's right. And
do
Berta,
not run with the land.
that's right. And the complication in our case law is between Berta and Cavanis from 1916.
Well, I'm a Supreme Court.
The holding in Cavanis in 1916 is that essentially any claim sounding in inverse condemnation travels with title. So unless a landowner who owns the property at the time that the damages were imposed asserts his claim for damages prior to transferring to a subsequent purchaser, that claim travels to the subsequent purchaser. That's for claims sounding in inverse condemnation. In Cavanis, they distinguished that from any claim sounding in trespass.
Okay, so let's say the DOT parked a truck on my property for 6 months. Then I sell the property a month later. I'm sorry, then the DOT moves the truck, and then a month later I sell my property. There's a 6-month claim I have, and it hadn't been 2 years. Do I own it, or the person I sold the property to have that claim?
Under Cavanis, well, the
Does
issue
Cavanis
would
not
be
really cover-
whether the department's parking of a truck was a taking.
Let's say it was a taking, and they did it for 6 months, then they stopped. And
Then it
a
would
month
travel
later,
to
I
the
sell-
subsequent
then-
purchaser.
Then I sell, you say it would go to the subsequent purchaser.
Under Cavanis, it would go to the subsequent purchaser. That's right.
Okay, I'm gonna have to look that case up. Okay, thank you.
Okay. First and
Y'all cite that case?
yes, Your Honor, that is in the the cross-appellant brief, Your Honor. And Cavanis goes to an issue of standing, just to round out this point. That's a matter of standing.
Well, that's not the issue. We don't have that issue here. I will say, in the Lee case, everybody cites this paragraph, but there's the paragraph afterwards where the Supreme Court says on page 633, even if we were to adopt the view in Bragg that Bragg requires a property owner to recover damages for an inverse condemnation claim of his property in a prior ongoing action for partial taking, a view which we specifically reject,
That's
the
right.
defendant here could not prevail, because in this case, the taking hadn't occurred at the time that the ongoing case here. So, but it says they reject the view that they have to do it.
With respect to subsequent further takings by the state. The issue of sequence in this lawsuit is key on every level. What happens when and what happens at those moments? Both Bragg and Leah and all of the subsequent cases by this court talk about the landowner's right to bring later claims for subsequent further takings by the state. The facts in Leah and Bragg, they're both about flooding that happened on the property after the department had filed a complaint and initiated construction. And at that point, there is flooding, which the court recognized was the basis of a claim in inverse condemnation for a flooding easement, or at least for damages caused by that flooding.
Why should
But
the
the
rule be
key
different?
is that
Why should the rule be different? Because I guess you're saying there is no case, because I think you say in your brief, no case has ever held this for prior whatever, but I guess no case has ever talked about it. So
The reason why it is important that those cases carve out a limitation in the scope of, frankly, the language of 136, 111, and the consent judgments is because the eminent domain statutes, the statutory scheme, functions to funnel all prior existing claims on the tract of land subject to condemnation into the condemnation proceeding itself. That's why, ultimately, 136, 111 is expressly identified as a remedy where no declaration of taking has been filed, and goes on to say that when there has been a taking and the department has not filed a complaint and declaration of taking, thus initiating a condemnation proceeding, the landowner then has a claim under 136, 111. But whereas here, the department did file a complaint and declaration of taking, thus making available to the landowner the ability to raise those prior existing damages in their answer as a counterclaim, or even failing, raising it in the answer and or as a counterclaim in a hearing under 136-108, which expressly invites the landowner to raise any and all issues raised by the pleadings.
But you said if the DOT has filed a complaint to take my land, but then does a subsequent taking after the complaint's filed, I can file an inverse condemnation claim?
Absolutely.
Why? Because you just said here, it says, okay, you take my land, you file a complaint. Well, I can't do it because it says no complaint has been filed.
That's right.
You've already filed your complaint.
That's
I can't
right.
bring an inverse condemnation claim.
Our Supreme Court
Says we can't-
clarified the limitation of scope. Right? This limitation applies to prior existing claims.
When does it do that?
Claims that come subsequent, precisely because, as Your Honor has noted, the landowner doesn't know about those claims until further down the road when proceedings are already ongoing.
But I'm in the action, so I could, here it says, well, I know once the case is over, I can't do anything, but I could do it, but where has the Supreme Court said their rule is limited to subsequent? I know this case talks about, is dealing with subsequent takings, but have they ever said, we're not talking about prior takings? Do they, would you say it's a case of first impression, there's no definitive statement on it?
It's a case of first impression in the sense that there's never been a need for the court to opine on the express limitation articulated in 136, 111. I mean, the language, it's just the plain language of 136, 111.
Well, the plain language would mean that if
identifies
you sue me in condemnation and a week later you take something else and I'm in a lawsuit, the plain language says I can't bring an inverse condemnation because a complaint's been filed. It says, the plain language, I can do it if no complaint has been filed. That's the plain language. And so,
That's true. And
so,
to
so I
avoid
think
an
it is a
injustice.
case of first impression, and we have to wrestle with it because I don't think plain language really helps, at least in my hypothetical, because that would be a subsequent taking. And the plain language says, no complaint. I mean, it's been filed, and the complaint's been filed.
Well, that's right. The need to articulate a limitation in scope with respect to subsequent further takings is justified and sort of made intelligible by the fact that there's a presumption with respect to prior existing takings that those will be raised within the condemnation proceeding.
Not takings that could take place after the complaint is filed, because my answer's not due for a while. How long do I have to file an answer?
That's right. Well, up to 1 year.
Yes, so if you take something 4 months after the taking, I still don't have to raise it under the Supreme Court. But if you took something if you took something separate a week before you filed your complaint to take this, I have to bring it up. But if you take it a week after you file your complaint, I don't have to bring it up, is what you're saying the rule is.
That's right. Although at that point, Your Honor, it would become an issue of res judicata. Because the doctrine of res judicata applies to both the claims that were raised and those that could have been raised when a plaintiff had the full opportunity to do so. And in a circumstance like the one that you are identifying, the landowner would have an opportunity to raise it in his answer, to bring it as a counterclaim, or to raise it in a 108 hearing. Right,
But if
the
it's a
imminent,
separate, if it's a separate taking, do I have to bring it? Are you saying it's a compulsory counterclaim? It's not, it's a taking. If you took an easement over here on my tract of land, but then you file a complaint to take this easement over here on the same tract of land, it's a different taking. But are you saying that I have to bring this as a compulsory counterclaim when you file your action to take this easement? There's two different takings. Because in this case, the Supreme Court said that 1992 is a different taking than when you filed your 2010 case. There's two different takings. So if it's not compulsory, it doesn't sound like it's compulsory because the Supreme Court said that if it's afterwards, I can file a separate inverse. I don't have to do it.
that is true. If it's afterwards,
But you're saying it's compulsory if you took this other easement a week before you filed the complaint to take this easement over here, but it's not compulsory if you take it a week afterwards. That's the line you're saying the Supreme Court has drawn.
then it would be an issue, that would be a factual issue. But
Okay.
to turn it back to the facts of this case, which I think are significant on this issue. When DOT filed its complaints in 2002 and in 2010, it identified as part of those complaints the same entire tract of land that had previously been subject to MAP Act recording.
And specific interest in those lands that it was taking.
And, yes, Your Honor, and identified fee takings of the majority of the same acreage that had been restricted under the corridor maps.
As of, they were taking a fee simple title as of
That's right.
2002, 2010. They were not taking, they didn't describe a taking of easements that they had taken in 1992.
That's right,
Okay.
because those easements were taken, they were on the public record, and they were effective as of the date of the recording of those maps. There was no need, once the parties arrived at the consent judgment, to identify those issues. Those negative easement takings were already part of the public record. Now, at that point, I mean, the key about the taking of the fee simple interests, of course, is just to take the bundle of sticks metaphor. The MAP Act had restricted 3 sticks in the bundle. When the department comes in later and pays for the entire fee, it is of necessity paying for the 3 sticks that had been restricted under the MAP Act. So in this case, the plaintiff negotiated for and accepted just compensation.
It depends, because in 2010, the sticks that the DOT's paying for is this piece of land that DOT's already taken the negative easement stick. That's gone. Sanders doesn't own that anymore. So when you
That's
buy
right.
it in 2010, what you should be paying for is this, the rest of the sticks that he has, which my question then was, should not have been that much. I mean, I don't know his land, but let's say that the MAP Act totally obliterated almost all value of his land and it reduced it to $1,000. The only stick he still has in 2010 is a $1,000 stick, and I hope that that's all y'all paid for it. But if you paid $1 million, that doesn't mean that's all he had. The before and after value would be $1,000 and then zero because you took it.
So you're right. Here's what the DOT paid for it under the 2011 consent judgment. In 1992 and 2006, the department acquired negative easements restricting 3 rights. On the date of recording those corridor maps, the department acquired a vested interest in a negative easement, and the landowner acquired a right to just compensation for that taking. In 2011, by acquiring the entire fee at the unencumbered and appreciated rate, DOT was then paying for the 3 sticks in the bundle that it
Well, you
had.
make a good point. So let's say I'd gone to Mr. Sanders in 2009 and bought his property.
Yeah.
I would acquire everything, right? Because I'm the new, under Kavanaugh, was that the cabinets were they, okay, you're saying I acquire it. So is your argument that when the DOT acquired the fee, then since all these inverse condemnation claims run with the land, it would flow to DOT anyway?
Under Cavaness, that's what would happen.
Because if I bought it from him, you're saying that I would own it. If I bought it from 2009, I would own the rights. He would, and so if you condemned it, I could go get everything.
That's
even
right.
Even the 1992 taking is what you're saying.
That is correct under
Okay, I'll have to
Cavaness.
go read that case.
Now, what would typically be the case is that prior to selling you the property in 2009, the landowner files a claim for inverse condemnation for damages. But then when he sells the property to you, you knowing that that inverse condemnation case is
negotiation.
ongoing, you would pay less.
Yeah, it comes down to, am I gonna pay him $1 million or $1,000? Because assuming, I'm just hypothetically.
That's right.
not-
You would be buying the encumbered property, and they would be seeking compensation for the encumbrance. That's how it would work. Now, in this case, in 2010, in the 2010 proceeding, the plaintiff had a choice. The plaintiff could have obtained a separate appraisal for MAP Act damages, assessed based on the change in the fair market value immediately before and immediately after the recording of those maps, and obtained a separate appraisal for the taking of the remainder of the fee in 2010. That was an option. But the plaintiff here did not choose to do that. The plaintiff here chose to accept just compensation based on the full, unencumbered, and appreciated value of the fee, which of course raises the estimate of just compensation in the before condition because the property is appraised unencumbered. So they benefited from the higher before value and accepted just compensation on that basis. And in exchange for just compensation, they entered a consent judgment which expressly recognized that that compensation was for, as this court has
How do I
pointed
know
out,
the before value was unencumbered? Because if you come and take my land and it's got easements all over it, you're gonna pay me whatever it's worth in 2010. Whatever, I mean, if the DOT's already restricted the heck out of it, it's not worth much. I mean, I'm just, that's where I'm just getting stuck is, it seems to me the way it should have worked, in my mind logically, was in 2010 you paid the before and after value. What was it worth into 2010 for the taking? Not very much because it had this negative easement. And it didn't, unless y'all were negotiating based on all of it, and that's what this judgment, I mean, that's what the consent
in
judgment.
2010 they negotiated based on all of it. That's the key to getting to $15.8 million.
Because I'm trying to understand what your intent, y'all's intent was when you entered this consent judgment, and that would be at least some evidence in my mind, what numbers were y'all going off, or what were y'all's, I don't know, is that in the record anywhere, what y'all's appraisers were saying?
No, Your Honor.
Unfortunately, because that would be nice.
What is in the record is that both parties negotiated on the basis of appraisals that did not consider an encumbrance on the property. That's one way of compensating.
Where's that in the record? Is that, if that's in the record, that would be some evidence.
That's one of the trial court's findings of fact. And it was a stipulation of the parties. Sorry, yeah, here it is.
It's one thing to say they didn't consider the value of the negative easement. It's another thing to say that we're appraising this property assuming it wasn't encumbered by any easement. Is that what you're saying to stipulate?
That's right.
Where is that? I mean, that would be some evidence what y'all intended by your consent judgment, whether or not you meant for damages for the acquisition, because it's sort of a contract between the two of y'all.
Oh, goodness gracious. I apologize, Your Honor. Record page 105, this is finding of fact 3T. All of the appraisers employed by either party valued the subject property immediately before the taking without
that's fair.
consideration of the MAP Act
Okay,
restriction.
you'll have to answer that one, because that's a good, because so, okay, so that's what y'all were, that was what y'all were trying to do, okay.
So in exchange for doing that, as this court has noted, in paragraph 5 of the 2011 consent judgment, that just compensation at $15.8 million is for number one, the herein described interests and areas. And as this court has rightly noted, if it's just compensation for the taking of those interests and areas under 136-112, the measure of damages statute, it automatically includes all damages caused by that taking to the remainder. That's number one. Then number two, interests and costs. Number three is one of the first of the two key provisions for any acquisition for the construction of the project. Now, the MAP Act, of course, was an acquisition of a negative easement for the construction of a highway project. There's no other way to understand that in the practical context of the fact that this is about acquiring rights to build a highway.
Well, to me, it still seems like two separate takings. There was a taking in '92 and there was a taking in 2010. And typically, what should have been done, if I was arguing, I don't know this, I'm just thinking top of my head, if I was arguing, I would say the before and after value is you got this encumbered piece of property before and then you've taken it. But y'all settled it. And so I'm trying to understand, is y'all's settlement include these past claims as well, which you're free to do?
It includes everything, Your Honor. But by the plain text of the consent judgment, it covers everything. There were absolutely two takings. On 1992, on the date of recording the map, that was a taking of a negative easement. It was complete as of the date of recording the map. 2006, same thing. 2002 direct acquisition, it is different.
Yeah, your 2010 complaint does not talk about compensating for that taking. It's just that the consent judgment, I'm trying to figure out, does that encompass any and all claims that could have been made or blah, 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 associated with that project, which could include other takings that might not have been covered in the complaint. That's what I'm trying to, I think if you'd gone to a jury, you'd have a harder case because all that was before the jury should have been is the before and after value in 2010, which would not have included the
That's
negative
right.
easement issue.
So, Your Honor, the third provision of the 2011 consent judgment, acquisition for the construction of the project, it includes everything existing prior to that point that is an acquisition for the construction of the project. And under Kirby and Chappell, the Supreme Court has made clear that the MAP Act recording is an acquisition. One of the easiest ways to see the difference that that provision makes is by comparing it to the 2004 consent judgment with paragraph 5 of the 2004 consent judgment, and this is record page 74. That parallel provision in 2004 only talks about damages caused by the construction. In 2004, it is not for an acquisition for the construction of, it's damages caused by the construction.
Why is this not an argument for the compensation phase? In the sense that, you know, if your argument is we've compensated for the entire thing, I mean, we don't, you know, the jury hasn't been instructed yet on measure of damages. You know, you haven't argued that the remaining value of this negative easement is zero because it was, you know, extinguished prior, that the issue hasn't, or that, you know, that just compensation constituted the amounts paid under the consent agreements. I mean, why is this not an issue that is maybe not even ripe for us to decide yet?
As a jurisdictional matter, any question of area or title, which essentially means compensable area, is a matter for immediate appeal. That's why the department has filed its appeal now. It's about the compensable area. Part of the department's claim is that this has been paid for, but more fundamentally, as a legal matter, it is waived as a matter of statute and released as a matter of res judicata. It's waived because of the plain terms of 136.111.
But res judicata isn't necessarily an immediately appealable issue.
It isn't, except to the extent that it affects the area taken in this case.
Under 108.
Let me ask you a question, and maybe this is just part of my misunderstanding about compulsory counterclaims and consent judgments. So I'm just kind of going to think generally. Let's assume in January, Judge Dillon hit me with his car in the parking lot and was negligent. I'm mad at him in June and I go and hit him and punch him and I assault him. If he sues me in December for the assault and I just say, okay, yeah, you're right, here's a consent judgment for 10 grand, am I barred from bringing that negligence action? I don't think so, because that's a not compulsory counterclaim. That's a possible counterclaim I could have brought, but the consent judgment's not going to bar me bringing that. Why why is this separate type of taking necessarily barred?
It's not a separate type of taking, but your suggestion there is correct. The reason why in your hypothetical, why the claim would not be barred is because you have two entirely different causes of action. Here, and it's just inverse condemnation, as this court has repeatedly said, exists simply as a tool by which a landowner can compel the state to exercise its power of eminent domain. So, in a sense, direct condemnation takings and inverse condemnation takings, that they amount to the same thing. They are efforts to compel the state to exercise its power of eminent domain. Now, in this case, when DOT files a condemnation on the landowner's tract, it has first identified the subject tract as a part of the pleadings. The eminent domain statutes explicitly invite, under 136.108, any landowner to raise any and all issues at that time, if they haven't already in their answer or by counterclaim, for any existing damages on that entire tract. Secondly, in this case, it goes further. By its complaints, the state is identifying a fee taking, which necessarily involves an acquisition of the three rights that had been restricted by the MAP Act. And so under those two sort of bases, the entire tract and by identifying a fee taking of the acreage subjected to the map, this issue in this case is raised by the pleadings. That's what triggers res judicata. That's what triggers the obligation under res judicata to raise those damages in the proceeding itself, or they are released.
But not if the taking took place a week after the complaint's filed. I mean, I'm still stuck on, I don't buy this plain language of 111 because it just says any person that has intentional, anything taken, there's two conditions to file it. Something's taken and no complaint has been filed. So if you file a complaint and then, and we'll give you a little bit more time, and then a week later you take my property, the Supreme Court says I can file an inverse condemnation claim.
That's right. So I would argue, Your Honor, respectfully, that the implications of 136.111 and the plain language of it are as restrictive as it sounds, with the exception of the restricted scope carved out by the Supreme Court in Leah Company and Bragg. When it comes to subsequent further takings, landowners have more options. But that is a complete reason for remanding this case for the dismissal of the complaint.
So the Supreme Court didn't follow the plain language of 111?
It was not construing the plain language of 136.111 in either of those opinions. But the way in which the Supreme Court in those two opinions construed the limitations of a consent judgment or the limitations of a 108 order under the facts of those cases do suggest the importance of the language in 136.111 and the way in which it stops being a remedy for landowners once the department has initiated a direct condemnation action. And this court has been extremely protective of landowners' ability to raise any and all prior existing claims on the tract. Right? We have been at pains to identify another realm of our statutes as accommodating as the eminent domain statutes. Landowners are able to raise their claims in an answer, by counterclaim, or failing both of those in a 108 hearing. I mean, they have multiple opportunities. And because of those robust opportunities and the way in which the DOT's condemnation complaints bring the entire tract into the scope of the proceeding, that's why the landowner was required to raise it here. But the res judicata, I believe, reinforces the statutory bar, but it is independent of the statutory bar. Res judicata in this case has two aspects. One is based on the language of the 2011 consent judgment, right? Acquisition for the construction of the project that directly identifies map act takings because, as Your Honor has rightly suggested, there is nothing else it could mean. And there is a reason why in 2002 the consent judgment didn't include that language, but in 2010, when the department was actively litigating map act cases, it did.
I'll give you like 3 minutes to wrap up if you want to.
Okay.
Unless y'all have any questions.
The last part has to do with use, right? The Supreme Court of North Carolina and both Kirby and Chappell talked about the map act negative easement as by definition a limited use of the property. And has also been noted, every eminent domain taking is a taking for the public use of a landowner's interests or property. So use is as broad as it seems in this consent judgment. And as this court has made clear in Weaver v. St. Joseph of the Pines, another case that we cite in our brief, this is 187 NCAP 198 from 2007, the language of a release in a consent judgment or any settlement agreement may be broad enough to encompass even claims that were not contemplated at the time, right? So against that background, the effort to somehow restrict the definition of any past and future use is simply at odds with the plain language of the provision. Now, lastly, one matter that hasn't been touched on here is the landowner's desire to ask for a different measure of damages than that which has been applied under Kirby and Chappell and has applied to hundreds of MAP Act litigants since then. It's simply a baseless effort that is inviting this court to overturn the established law of the MAP Act to give this particular plaintiff a different measure of damages, which would grossly overcompensate.
Well, they seem to say today, though, that they're not advocating for a different measure of damages. That they're willing to abide by the sort of the diminution in value measure, but just that maybe that's impacted by the length of time upon which the easement existed, which
Under
to me
Kirby
would
and Chappell,
suggest that
The
it might be a
taking-
mitigation of damages.
that's right. But what is misleading about that suggestion is that under Kirby and Chappell, the MAP Act taking is assessed as of the date of the recording of the map. And it's based on the mandated measure of damages, as the court in Leah Company identified, and in Kirby and Chappell, based on 136-112. As of the date of the recording of the map, you then measure the change in the fair market value of the entire tract from immediately before to immediately after.
But the trial court's order here, under review, though, does not address specifically measure of damages, though, correct? I mean,
It doesn't. It leaves it,
so you can
in the
still
wind.
make that same argument at the compensatory phase as to
but-
what the measure of damages upon which the jury would be instructed.
The key move is that once it is declared a temporary taking, which is contrary to the Supreme Court in Kirby and Chappell, which held that it was an indefinite, it was a taking of indefinite duration as measured on the date of the recording of the map. Once you say it's temporary, you get into a year-to-year fluctuating rental value. That is the measure of damages that comes immediately in the wake of declaring it a temporary taking. That's why this law firm sought to convince the Supreme Court in Chappell in the amicus brief of the Owners Council of America to change, to not uphold the Kirby opinion's understanding of a MAP Act taking and to change it into a taking of temporary duration. This is a second-level effort to invite the court to change the established law so that this plaintiff can have a different standard and measure of damages than has been applied. That's the whole reason why this has been brought. So the suggestion that it would not have the implications that we are arguing is simply misleading.
It's been about 30 seconds to wrap up if you want to.
Okay. The significance of this case is key for two massive reasons. One has to do with the effort to change the measure of damages by redefining the nature of the taking from what the Supreme Court has said it was to a temporary taking. That would overcompensate this plaintiff, and it would apply a different measure of damages to all pending MAP Act cases that is different from the basis upon which the department and landowners have settled literally hundreds of cases, taking its cue from the Kirby decision. The other significance of this lawsuit that this court should be aware of has to do with the way in which it threatens to reopen litigation in hundreds of cases settled by the department in counties where MAP Act corridor maps were recorded. The Department of Transportation, like in this case, prior to 2015, acquired and settled just compensation on untold numbers of cases. This plaintiff's effort to get around the plain language of 136-111 and res judicata would open the door to hundreds of additional lawsuits that would reach back in time and reinitiate litigation. That's precisely what consent judgments or settlement agreements of any kind and 136-111 are designed to prevent.
Well, to the extent that it's not 2 years after whatever project.
To the extent that it's not 2 years after whatever project. But part of the issue about why these consent judgments and releases are so important is that construction projects go on for years of necessity.
Thank you,
Right.
counsel. Thank you.
Thank you.
We'll hear rebuttal.
Thank you, Your Honor. I'll get back just to addressing a question you had earlier. Judge Dillon, you asked about damage that could be part of the acquisition for construction, but not a separate taking. And sitting here, what came to mind for me is proximity damage. Proximity damage is not a separate taking, but when your property's taken, let's say you own a house, and they build a highway next to your house, and now you're 10 feet, your front door is 10 feet from the highway. That's not a separate taking, but what that is called proximity damage. That's a damage that's caused by the acquisition. Just to give you an example, I wanted to come back to that. The DOT paints with far too broad a brush. If you hit me with your car in '92 and you hit me with your car again in 2010, they're different causes of action. These takings are 4 different takings of 4 different property interests that occurred at 4 different times. There's no case anywhere that says the taking of one property interest, especially at a different time, is somehow a compulsory counterclaim to the taking of a separate interest. And in fact, the Supreme Court and this court have both addressed the very issue that the DOT tries to persuade you today, and that is if the inverse condemnation taking arose before the condemning authority filed its complaint, the DOT would lead you to believe the owner can't bring the inverse.
Well, help me with this example. You hit my car this year, causing my car to go down in value from 10,000 to 8,000. Then you hit it again a month later. It goes from 8 to 6, and I sue you for the second one. But then we sit and talk about settlement, and we settle blah, 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 and the way we value the car is based on the $10,000 value. We don't consider the fact that it's gone down in value. I've been compensated. Can I come back and sue you for the second, that first wreck?
What distinguishes that, Your Honor, is it's not an accident situation. It's a power of eminent domain where the government takes the property by force for a particular project. They are not allowed to do in 2 steps what they couldn't do in 1. And what I mean by that, the government can't, if the government were to take, if they took all these interests at the same time, Mr. Sanders gets paid. The fact that they took them at different times doesn't mean they get a condemnation discount. And let's think about somebody who has their property taken in 2019. Their property is no longer encumbered by the MAP Act. It's been repealed. They get paid as if their property's free and clear for the same project, same direct condemnation, but they also got paid for the MAP Act. They got paid for both interests. Why is Mr. Sanders singled out and treated differently? It's all about the interest taken, and they paint with far too broad a brush. When they talk about the DOT or condemning authority has to identify the entire parcel, yes. But what the case law makes clear is they also have to identify the interest taken. The only thing an owner is required to raise in a condemnation proceeding is any damages from the interest taken. If the DOT is correct about their interpretation of past and future use of the property, once they settle any condemnation with an owner, that owner can never recover again from them. because any past and future use is waived. That's far too broad a brush. That all relates back to the interest taken. That's how it's always been in the condemnation cases. And I again direct your attention to the Spratt case out of the North Carolina Supreme Court, which we cite, and then this court's decision, which I cited earlier in Farrell, which the DOT did not bring to your attention. Farrell was decided under the identical statute under Chapter 40A. It was a construction easement that arose before the condemning authority filed its complaint. And this court, relying upon the statute and relying upon Spratt, said the owner is free to bring a condemnation claim. They haven't even attempted to address Farrell because they can't. They just misled the court.
Wait, Farrell said that if there's a prior taken, what happened in Farrell again?
In Farrell, Your Honor, there was the city had taken a construction, they had just used this owner's property
Okay.
without filing any complaint or declaration of
Okay.
taking. After the city did that, the city then came along and filed the direct condemnation action so it could build its road.
Okay.
And the owner sought to bring an inverse. And the court said that's fine. The court said under the statute, citing Spratt, even if the inverse taking arose before the condemning authority filed its direct condemnation complaint, the owner is still free to bring the suit.
A separate inverse.
Yes, sir. There's no, or as a counter. Yeah, either way. The courts have been entirely consistent that an owner can bring an independent action or it can bring it as a counterclaim. If the DOT was so confident in its position, why then does it have consent judgments, which we cite in our brief and we quote, where they specifically make the owner waive his or her MAP Act claim? They know that their standard language doesn't speak to the MAP Act. They know that. And as far as this idea...
That case hadn't taken place yet, had it?
Yes, sir. And the cases we cite in our brief are cases where there was the MAP Act case.
No, I meant that when these consent judgments were entered in 2010, is that when the...
No, sir, I'm talking about consent judgments in other cases. We have other cases where the DOT entered consent judgments, and in those consent judgments, unlike Mr. Sanders, the DOT put in language specifically requiring those owners to waive their MAP Act damages.
And those are part of the record in case
Yes, sir.
we decide there's an ambiguity and therefore it's
Yes, sir.
evidence of the intent of the parties when entering the consent judgment?
Yes, sir, that's in our brief, and we quote that. And the idea of them to try to make the measure of damages at issue here, that's not even at issue, but it's totally disingenuous, and this is why. Every day throughout this state, the DOT takes construction easements. When it files a direct condemnation complaint to build a road, it also needs some additional land for construction. And the DOT takes construction easements, and those construction easements are identically indefinite to the MAP Act. They're designed to last until the project is complete, which was originally what the MAP Act was intended to do before the legislature repealed it. And guess what? In every one of those cases, the DOT labels that indefinite taking as a temporary construction easement. And in every one of those cases, they value the property, just like the property owners, under the before and after method. That's a total red herring to come in here and act like, number one, valuation's even at issue yet, and number two, to act like you can't take something that's indefinite that ultimately becomes temporary when it's repealed and value it on the before and after. They do it every day in courts throughout the state. And I would just end on this. To the extent the DOT says it's going to open round two, our firm represents as many property owners as probably anybody. We've been doing this exclusively for 20 years. We don't have tons of...
None of that's in the record, though.
No, sir. Yeah, no, we don't have tons of...
I mean, I appreciate it.
Yeah,
I understand.
I'll just end on this, then. The Pandora's box argument. If their argument is, well, this is going to be too expensive, it's going to open up more suits, my response is this. Mr. Sanders, and this is in the record, is 87. He's been dealing with this for 30 years. His property was encumbered for 2.5 decades. It's 700 acres outside the gate of Fort Bragg. So when you look at the value, commercial land, that might tell you it's been frozen. This man's not been paid for those restrictions that encumbered his property for 2.5 decades. And it's very clear, from 92 to 2010, he had 112 acres that were encumbered and restricted. From 2010 to 2016, when the MAP Act was repealed, he had 28 acres that remain encumbered. To this day, he hasn't been paid. There's no reason he shouldn't be treated the same as other MAP Act owners, regardless of when they filed their direct condemnation action. He has to be paid for each interest that was taken from him.
Okay, I get it, okay.
Thank you, Your Honors. I appreciate your time.
We'll take it under advisement.
All rise. This session of the North Carolina Court of Appeals is now adjourned.